SwayamPrabha. Digital India. Educated India.
Hello friends, myself Dr. V. K. Pathak from Faculty of Law, Banaras Hindu University has come before you with a new course on the subject law relating to women and children. Different topics relating to the law on women and children. The first topic which we will discuss in the present session, that is lecture 1, protection of women and children under international law. It is the fact that the women have been the subject of exploitation, the subject of discrimination, the subject of indignity, the subject of arbitrary actions, and therefore, it has been a marginalized group of human being from any ancient period, and therefore, it became essential to take effective measures, to take effective actions or initiatives to improve the position of status of women and children both. Because of the marginalized position of women, the children have also been exploited, discriminated, and they could not avail their basic human rights. So, these two groups are said to be very vulnerable groups whose human rights, whose fundamental rights, even basic rights are always under the threat. And therefore, the international community came forward for thinking about the improvement relating to the protection of rights of women and children, and therefore, this topic is very relevant for understanding the law relating to women and children, that what international initiatives have been taken, what international law has been developed, the law relating to women and children. So, if we talk about the law relating to the women and children, then it is certainly truth, or it is correct to say that women around the world have regularly been suffering discrimination, exploitation, ill treatment, domestic violence, indignity and disrespect, and thus violations of their human rights throughout their lives. It has not always been a priority to understanding and appreciating the human rights of women at both national and international level, but it has been the approach of United Nations from very outset of its establishment that to attaining equality between women and men and eliminating all forms of discrimination against women, that has been the fundamental human rights and United Nations value. A comprehensive understanding of the forms of discrimination, the ways in which women experience discrimination and they are denied equality is required for ensuring equality between women and men, for developing proper and suitable policies and schemes to eradicate such discrimination. From very inception, the United Nations has been addressing the issue of human rights of women, and it is also correct that significant progress has been made in this regard to secure women's rights and to protect them from any kind of discrimination and exploitation. It is also true that important gaps still remain, particularly because of frequently and persistently changing women's realities and new indicators, forms and manifestations of discrimination against them. it has also been experienced that some women also face superfluous and excessive forms of discrimination based on their age, place of origin, ethnic group, nationality, religion, health conditions, nuptial status, education, disability and socio-economic status, among many other grounds. And therefore, it is necessary that these traversing forms of discrimination must also be taken into consideration at the time of evolving methods, measures and reactions in combating discrimination against women. Since the formation of United Nations organization, it has been its central theme that equality between men and women is the most fundamental guarantee among many other guarantees of human rights. To affirm faith in fundamental human rights, in the dignity and worth of the human person and in the equal rights of men and women has been set out as one of its objectives by the Charter of the United Nations adopted in 1945. This charter seems to be, or it has been, the first human rights charter or first document prepared by the United Nations organizations with regard to the protection of human rights of the persons or the human rights of the human being. If we see Article 1 of this charter, Article 1 of the charter specifies that one of the commitments of the United Nations is to promote respect for human rights and fundamental freedoms without distinction as to race, sex, language or religion. These have been the important grounds on which the discrimination should not be there. Article 1 of the United Nations Charter on Human Rights, it includes even in very outset of its document, that is Article 1, that there should not be any discrimination on the ground of race, on the ground of sex, on the ground of language and on the ground of religion. So, sex was the one of those grounds on which the United Nations Charter in 1945 wished to, or it was willing to stop such a discrimination based on the sex. That means that from very inception of the creation of the establishment of UNO, United Nations organization, it has been the central theme of United Nations to stop or to prevent the discrimination on the basis of sex. That means that the United Nations approach from its very beginning has been that the women and men, these are two equal human beings, or these should be treated on equal footings. They should not be treated discriminatory. There should not be the discrimination with the women because of their sex, only because of the region, only on the ground that they are men or they are women. That discrimination should not be allowed. This prevention and exclusion of discrimination on the basis of sex is again restated in Article 13 of the Charter. See Article 13 of the Charter, which relates to the mandate of the General Assembly, and Article 55 on promotion of universal human rights. So, again you see in Article 1, in Article 13, then in Article 55, 3 times in this charter the United Nations organization was of the view, was of the approach, was of the this thought or opinion that there should not be the discrimination on the basis of sex. Men and women both should be treated equally, there should not be inequality between the men and women based on the sex only. In 1948, the General Assembly of United Nations organization adopted the UDHR, the Universal Declaration of Human Rights. This Universal Declaration of Human Rights, it also pronounced the equal claims of women and men to all the rights contained in it without any kind of distinction or discrimination on the basis of sex, amongst all other ground. During the finalization of draft, the declaration, there was substantial discussion on the use of the word, whether the word men should be used or whether any gender neutral term should be used in place of all men. After the long discussion, elaborate deliberations in the United Nations organization, when UDHR draft was finalized, then finally the UDHR adopted the term all human beings in place of all men. All human beings and the everyone, these two terms were used by the UDHR, and these two terms were, it seems that these two terms, the all human beings and everyone, these were used by the UDHR in final draft of the UDHR. These were to ensure the removal of any doubt that the Universal Declaration of Human Rights was intended to guarantee the human rights for everyone, irrespective of the sex, irrespective of any other ground. So, when these two words were used, it means that UDHR was of the intention that these human rights which are contained in this document, these are guaranteed to all the human beings irrespective of their sex. It means the men and women both were treated by the UDHR equally, and all the rights contained in UDHR was guaranteed to both the men and women on equal footing. After the adoption of UDHR, the United Nations Commission on Human Rights started to work on two more human rights treaties, and as a result, the International Covenant on Civil and Political Rights and the International Covenant on Economic, Social and Cultural Rights were adopted by the General Assembly of United Nations Organization. The International Covenant on Civil and Political Rights, which is known as ICPR, and International Covenant on Economic, Social and Cultural Rights, which is called as ICESC. These two international treaties, these two international agreements, these two international documents were adopted after UDHR. You see that there is the continuous consistent evolution of the human rights, and therefore, the human rights which were initially guaranteed all over the world to all the human being by UDHR particularly, these are known as the first generation human rights. Then the next generation of human rights comes in the form of the social rights, the economic rights, the cultural rights. By the adoption of these two international documents, by the adoption of these two international treaties or covenants on the issue of human rights of all the men of the world, two generations of human rights were covered, and the provisions of these two covenants and other human rights treaties, these are legally binding on the member states that ratify or accede to them. These two international covenants together with the UDHR are said to be the International Bill of Human Rights. You can understand the importance, the significance of these three international documents: the Universal Declaration of Human Rights, the UDHR, then International Covenant on Civil and Political Rights, then International Covenant on Economic, Social and Cultural Rights. These three documents or these three international initiatives, these three international efforts in protecting the human rights of all the men or the human rights of everyone, human rights of human beings, are called to be or said to be the International Bill of Human Rights. Both covenants use the same phraseology as adopted by UDHR. In place of all men, the term human beings was used and everyone was used. It also indicates that all these three international initiatives with regard to the international law relating to the human rights of the human beings, these all the three initiatives, all this international bill of human rights was of the opinion or was of the intention that there must not be any discrimination on the basis of sex, and men and women both should be entitled to all the basic rights, to all the human rights, only for being the human being and not for being men or women, and therefore, there should not be any priority with regard to the entitlement, with regard to the guarantee of rights or basic human rights to men and women, both should be treated equally. In 1967, the member states of United Nations organization adopted the Declaration on Elimination of Discrimination against Women. The declaration enunciates and pronounces that discrimination against women is an offence against human dignity and calls on member states to obliterate existing laws, customs, regulations and practices which are discriminatory against women, and to establish adequate legal protection for equal rights of men and women. Just try to understand one thing, that first the Universal Declaration of Human Rights was adopted, and before this the Universal Declaration of Human Rights, the UN Charter on Human Rights was declared, the UN Charter on Human Rights, the Universal Declaration of Human Rights, then two covenants for the protection of or to ensure the protection of human rights of all the human beings of the globe. In spite of these four important or significant initiatives by international community to protect the human rights, and the particular initiative of the international community to protect the human rights of both the sexes, the men and women, without any discrimination, without any inequality. Irrespective of all these initiatives and in spite of these initiatives taken by the international community, the situation or the position of women could not be improved because of some social and traditional mindset, social and traditional approaches, because of some practices, because of some religious practices, because of some customs, the men and women could not be treated equally, and all the human rights which were guaranteed by the International Bill of Human Rights could not be availed by the women on the equal footing with men, and therefore, the international community thought that the discrimination against the women cannot be prevented, cannot be stopped until and unless the specific international law or the specific international initiatives to protect the rights of women are taken, and the member states or the countries, they include such laws in their national legislations for improving the situation of women and for guaranteeing the rights of women or to protect the women against any kind of discrimination. For this purpose, the Declaration on the Elimination of Discrimination against Women, it came into existence. The declaration enunciates, it declares and pronounces that discrimination against women is an offence against human dignity, and calls on member states to obliterate existing laws, customs, regulations and practices which are discriminatory against women, and to establish adequate legal protection for equal rights of men and women. That was certainly very significant initiative on the part of international community, on the part of United Nations organization, that the declaration on the elimination of discrimination against women was made, and by this declaration the will was expressed that all the member countries or all the states, all the countries should obliterate existing laws, the customs and regulations and practices, not only the laws, but also the customs and practices which are derogatory to the women or which are in any way discriminatory to the women. And this declaration certainly was a new kind of this was the starting point of new kind of approach, new kind of mindset or new kind of strategy to protect the rights of the women. After the adoption of the declaration on the elimination of discrimination against women, a proposal was made by the member states of United Nations for adopting legally binding treaty on the rights of women. In this series, development of international law for the protection of women against any kind of discrimination and exploitation, the General Assembly of United Nations adopted the Convention on Elimination of All Forms of Discrimination Against Women in 1979. In 1967, the Declaration on Elimination of Discrimination Against Women was made, but that declaration was not legally binding over the member states of the United Nations, and therefore, it was thought that to improve the situation of women or for the protection of women against exploitation and against the discrimination, there should be a legally binding treaty or legally binding convention to which all the member states of United Nations, they should be obliged to accept the provisions of or the initiatives of such treaty or such convention for preventing the discrimination and exploitation against women. If we see the preamble of this convention, the preamble of the convention expounds and admits that despite the development of international humanitarian law and the existence of several international instruments on human rights, women still do not enjoy equal rights with men. It is very important to make or to focus on this particular part of the preamble, where the United Nations or the General Assembly of United Nations was of the opinion, or it realized, despite the international instruments on human rights, the women could not be or the rights of women could not be protected, the discrimination against the women could not be prevented, the exploitation against women could not be prevented, and still the women are not in position to enjoy the equal rights with the men, and therefore, this convention was adopted. This convention speaks clearly, and it also explains the nature and the meaning of sex based discrimination. It also imposes the obligations on the member states to eradicate the discrimination and to achieve, to accomplish the functional equality between men and women, the pragmatic equality, the functional equality, not equality in principle, not only the equality in theory or theoretical equality. It was of the opinion that the member state should eradicate all those practices, all those laws, all those customs which are discriminatory to the women, and they should achieve or accomplish the functional equality. The convention pronounces that states are obliged to address not only discriminatory laws, but also practices and customs which are discriminatory or derogatory. It also covers the discrimination against women by private actors. These are two important aspects of this convention. We all know that the law cannot function, the law cannot work, the law cannot achieve its objective unless and until the social mindset is to enforce or implement that law or to accept that law. And therefore, it is also said in the field of law that law should be in accordance with the opinion of the people. This is the matter of debate or discussion, whether the law should be in accordance with the opinion of the people or people should change their conduct or the people should adopt their conduct in accordance with the need of, in accordance with the requirement of the law. In the field of jurisprudence, both kinds of situations we can see. You can take up the Widow Remarriage Act as the example, the Sati Prevention Act. Though it was not in accordance with the opinion of the people, but it certainly changed the mindset of the society. These laws changed the attitude of the society, and these laws could be enforced because of this changed mindset of the society or the people. And therefore, the social changes are required. Change in the mindset of the society is required if we want to make or to bring the women on equal footing with the men. The international community or United Nations, General Assembly of United Nations or the international community or the member states, they could understand this point that only by making the declarations, only by enacting the laws, the position of the women, the status of women could not be improved unless and until we hit such social practices, such religious practices, such customs which are derogatory to women or which allows the discrimination against women or which allow the discrimination on the basis of the sex. And therefore, this convention first time obliged the member countries to renounce or to eradicate the practices and customs which are discriminatory or derogatory to the women. It is also the unique feature of the convention that it covers the discrimination against the women by private actors. The convention consists of the preamble and 30 articles and is considered to be the International Bill of Rights of Women. This convention outlines what constitutes discrimination against women and also sets up an agenda for national action to end such discrimination. It does not constitute the discrimination, it does not tell us about that what is the discrimination against the women or what actions, what activities, what kind of the decisions or actions amount to be the discrimination against a woman, but the convention also sets up an agenda for national action to end such discrimination. This convention has been ratified by 189 members of United Nations. India signed the convention in 1980 and ratified it in 1993 with certain reservations. The United States of America has signed the treaty, but it did not ratify it. By participating in the convention as the member state, India had and India has become legally obliged to take all proper and suitable initiatives to eliminate all kind of discrimination against women and promote gender equality. The obligation of member states apply to both public as well as the private life. And this aspect of the convention is also significant because one of the major hurdles in securing equality to women with men has been the outlook that the state should not interfere in the private life of individual, and this outlook was changed by this convention. The convention imposes the obligation on member states to ensure that women are not discriminated against in the private domains of marriage and family life. In personal laws also, that has been the very important feature of the convention, that it also deals with the private life of individuals in matters of discrimination against women. It also includes within its ambit, within its range, the personal law or the domains of marriage and family life. Because if we see the personal laws of different religions, either it is the Hindu personal law or Muslim personal law, Christian personal law, Parsi personal law, at one or another place in these personal laws we find the discrimination on the basis of sex. After the codification of Hindu law, there are less opportunity to discriminate the women against the men, or to make the discriminatory behavior, or to deal the men and women discriminately or unequally on the basis of sex. But still you will find some provisions in these personal laws. In Muslim law, we know that how the women are being discriminated, in other laws also, personal laws also, and therefore this has been the very important obligation imposed over the state, that states should also take care of the private life of individuals, or they can also make the laws, or they had the mandate, international obligation to improve their personal laws with regard to the equal behavior with men and women. It is also significant feature of the convention that it confesses that equal power relations within the private spheres of life contribute greatly to gender inequality in all aspects of the life of women, and therefore it directs the member states to take effective steps for correcting this power imbalance. Article 1 defines discrimination against women as any distinction, exclusion or restriction made on the basis of sex with the purpose or effect of impairing the enjoyment by women of political, economic, social, cultural or civil human rights on equal footing with men. The definition of the discrimination against women, it is very broad, which was given by Article 1 of this convention, and it includes any distinction, any exclusion, any restriction made on the basis of sex. If any distinction is made on the basis of sex, if any exclusion is made on the basis of sex, if any restriction is made on the basis of sex, with the purpose or effect of impairing the enjoyment of women of political, economic, social, cultural or civil human rights. All the human rights, either these relates to the first generation human rights or the second generation human rights, are included within the scope of the meaning of the discrimination against women under Article 1 of the convention. Article 2 states that member states condemn discrimination against women and undertake to pursue a policy of eliminating it in all forms, to include the principles of equality of men and women in national constitutions, to adopt legislations prohibiting all discrimination against women, to ensure legal protection and effective remedy against discrimination, to refrain from any act of discrimination against women, and ensure that no public authorities or institutions engage in discrimination, to take measures to eliminate discrimination against women by any person, organization or enterprise, to take measures to modify or abolish existing laws, customs and practices which constitute discrimination against women. Article 3 states it requires that state parties shall take all appropriate measures, especially in the political, social, economic and cultural fields, to ensure that the full development and advancement of women for the purpose of guaranteeing them enjoyment of human rights on equal footing with men. Article 4 requires the affirmative action measures. Special measures protecting pregnancy shall not be considered discriminatory. The affirmative action measures are allowed, though the discrimination is not allowed on the basis of sex, but if any such discrimination is made in favor of the women because they are the part of the marginalized group, and therefore, if any discrimination is made in favor of or in protecting the women, that would not be discriminatory. That means that the affirmative discrimination or affirmative discriminatory actions were allowed by section 4. Section 5, state parties shall take all appropriate measures to modify social and cultural patterns of conduct of men and women which are based on ideas of inferiority or superiority or on stereotyped roles of men and women, to ensure that family education includes the recognition of the common responsibility of men and women in raising children. Article 6, state parties shall take all appropriate measures to suppress traffic in women and exploitation of prostitutes. Under section 7, states are required to take appropriate measures to eliminate discrimination against women in political and public life, and the member countries are required to ensure equal rights to vote and the eligibility for election on equal footing, the equal participation in forming government policies and the equality in holding the public offices, the equality or equal treatment to participate in non-governmental organizations. Article 8 requires that state parties shall take all appropriate measures to ensure women's equal right to represent her government. So, they can enter in political fields equally with the men, they should have the right to vote, they should have the right to participate in governmental affairs, they should have right to participate in making the governmental policies, they should have the right to hold the public offices, they should also have the right to participate in the different or various activities being organized by the non-governmental organizations. So, on equal footing in every aspect of life, in each and every field of the human development, women were guaranteed the right to equality to participate in all these activities. Article 9 of the convention, it grants the women equal right to nationality, equal right to the citizenship, and it was stated in article 9 itself that neither the marriage and nor the change of nationality by the husband during marriage shall automatically change the nationality of the wife. Women shall have equal right with men with respect to their children's nationality also. In article 10, the state parties are to ensure the same conditions for career guidance, access to studies, same teaching staff and equipments, stereotyped roles of men and women are to be eliminated in accordance with the mandate given by article 10 in all forms of education. that the women can study only this aspect of education or these subjects of education, and they are not allowed to study the particular field. The women cannot study the defense studies, or they cannot go to serve the nation in defense forces. No, all such kind of discrimination is prevented by Article 10 in the field of education and in the field of career. Then Article 11, state parties shall take all appropriate measures to eliminate discrimination against women in employment, and shall ensure on the basis of equality of men and women the same rights, right to work, the same employment opportunity, free choice of employment, free right to the promotion, benefits, vocational training, equal remuneration, equal treatment in respect of work, the right to the work of equal value, the right to social security, right to unemployment protection, the protection against the unemployment and health. And state parties are prohibited to dismiss the women workers on the ground of the pregnancy, and discrimination in dismissal on the ground of sex, on the ground of marital status of women was also prohibited by Article 11. Article 12 requires that state parties shall take all appropriate measures to eliminate discrimination against women in the field of health care, and shall ensure women equal access to health care services and appropriate services in connection with pregnancy. Article 13, to eliminate discrimination against women in other areas of economic and social life. Article 14 provides that state parties shall take into account the special problems of rural women and the significant roles they play in the economic survival of their families, and shall ensure to them all rights in this convention. In this regard, the state parties shall ensure equal rights of men and women to participate in the benefit from rural development, and shall ensure to rural women the right to participate in planning, benefit from social security programs, to receive the training and education, to have the access to agricultural credit and loans, marketing and appropriate technology, to receive the equal treatment in land reform, and to have the adequate living conditions, etc. Women and men shall have the same rights regarding movement of persons and freedom to choose residence under Article 15. So, different aspects of human life or different aspects of the development of the human being, these were included within the ambit of the rights being protected by this convention, and all kinds of discrimination was prohibited. One optional protocol was also introduced, was also adopted with regard to this convention, and optional protocol introduces additional mechanism for the implementation of CEDA, this convention. Article 23 to 30 of the convention deal with the administration of the convention or the CEDA. In addition to this, the Convention on Political Rights of Women 1952 was adopted. The Declaration on Protection of Women, Children in Emergency and Armed Conflict 1974 was adopted. The Declaration on Elimination of Violence against Women 1993 was also adopted. The Inter-American Convention for Prevention, Punishment and Elimination of Violence against Women was adopted in 1995. This is the development of the international law relating to the women, wherein we have seen that different or several international instruments, the international conventions, the international covenants, the international declarations were made and adopted, and member states of the United Nations or the member states of those treaties, conventions or agreements were made obliged to prevent the discrimination, to prevent all kinds of discriminations against the women and to ensure the equal participation of the women in all the fields of human development. The second part of this lecture relates to the international law relating to children. As I have already told you that the women and children, these are two very important groups of the human population all over the world, and these are two important parts of the human population of any nation in the form of the human resource, and therefore, they should be treated with very care and caution. Equally, the women equally with the men, without any discrimination, without any distinction on the basis of sex, and then the children are also they are also considered the part of very vulnerable group. The today's children will become tomorrow's human resource of any country. They will participate in the development of this globe, in the development of this world, and therefore, for making those children or for preparing those children to be the responsible citizens of any country, to be the responsible member of the human community, to be the responsible human being for ensuring the welfare of this whole globe, it is essential that from very beginning of the journey of the life of a human being, that is the childhood, the rights should be protected and all kinds of opportunities which are needed for the proper development of a child should be given to him or to her. And therefore, it is also important for us to understand the status of international law relating to the children. Friends, the inherent dignity and the equal and inalienable rights of all the human beings, including the children, are recognized and protected by international law. With the evolution, growth and development of global human rights drive in recent past, the children's rights began to be recognized independently. Before it, the children's rights were also included within the rights of all the human beings. But in the recent past, we see the significant drive of the international law, where the rights of children are specifically recognized and protected. The special provisions, the special international initiatives are being taken for the protection of the rights of the children. The somatic, emotive and psychological immaturity of children has also been acknowledged by the present day international law, and the present day international law recognizes that the children's distinctive and dependent status may create difficulties for them in chasing remedies for violations of their rights, and therefore, the international law now recommends the creation of distinctive measures to deal with the concerns of children. The objective of this distinctive approach, because of the somatic, emotive, because of the psychological immaturity of the children they cannot avail their rights or they cannot avail their remedies, the remedies under the rights recognized for all the human beings. The distinctive measures should be taken. The objective of this distinctive drive or this distinctive approach of international law for the protection of the rights of the children is to ensure that their vigorous and systematic physical, mental, moral, spiritual and social development in conditions of freedom and dignity may be made. International instruments on human rights law such as UDHR, ICCPR, the ICESR, the ECHR, ACHPR, the CRPD and Convention on the Rights of Persons with Disability, that is the CRPD 2006. All these consist of several provisions with regard to the rights, entitlements and safeguards to the children. For example, Article 25(2) of UDHR pronounces that motherhood and childhood are entitled to special care and assistance, and all children, whether born in or out of wedlock, shall enjoy the same social protection. Article 25 of International Convention on Civil and Political Rights enunciates that every child shall have, without any discrimination as to race, color, sex, language, religion, national or social origin, property or worth, the right to such measures of protection as are required by his status as a minor on the part of his family, society and the state. In addition to these general protections given to the children as the human being, they are also protected from employment and involvement in hostilities. Several special and specific legal benefits have been prescribed for children by new regime of international law, and some precise obligations have also been imposed on the state by recognizing their special needs and vulnerabilities. In this regard, 4 Geneva Conventions of 1949 and the additional protocols of 1977 may be referred to. Article 82(b) 24 of the Rome Statute of the International Criminal Court, which was adopted in 1998, declares that recruiting, procuring, registering and using children under the age of 15 years in hostilities is a war crime, and the offenders are separately and personally responsible for such an international crime against children. Though different instruments of international law provided for the protective measures for rights of the children, but it could not be found sufficient to fulfill the need of specified measures for the protection of children's rights, and therefore, in the recent decades some particular international legal instruments for the protection of children's rights have been evolved at both the international and regional levels. These initiatives by international and regional community seems to address children's issues in diverse circumstances of the children of different parts of the globe. For this purpose, these international instruments clarify the understanding ambiguities by making a clear explanation of the substantive principles of international instruments, and also by providing for some effective institutional mechanism to endure and implement the agendas, programs, schemes and policies at the domestic level. If we see the international instruments in this regard, these are the Geneva Convention of Rights of the Child 1924, the Declaration of Rights of Child 1959, the Minimum Age Convention 1973, the Declaration on the Protection of Women and Children in Emergency and Armed Conflict 1974, the Convention on Civil Aspect of International Child Abduction 1980, UN Standard Minimum Rules for Administration of Juvenile Justice 1985, the Convention on the Rights of the Child 1989, Hague Convention on Protection of Children and Cooperation in respect of their country adoption 1993, Convention concerning the prohibition and immediate action for the elimination of the worst forms of child labour 1999, the optional protocol to the Convention on the Rights of Child on the sale of children, children prostitution and child pornography 2000, optional protocol to Convention on the Rights of Child on involvement of children in armed conflict 2000, optional protocol to the Convention on the Rights of Child on the communications procedure 2012. Then we can see the regional instruments, the European Convention on the recognition and enforcement of decisions in matters of custody of children and restoration of custody of children 1980, the Inter-American Convention on conflict of laws concerning the adoption of minors 1984, the Inter-American Convention on the international return of children 1989, the African Charter on the rights and welfare of children 1990, Cape Town annotated principles and best practices on the prevention of recruitment of children into the armed forces and demobilization and social reintegration of child soldiers in Africa, April 1997, Convention on regional arrangements for the promotion of child welfare in South Asia 2002, Convention on preventing and combating trafficking in women and children for prostitution 2002, Convention on the protection of children against sexual exploitation and sexual abuse 2007. Then the most important convention relating to the international law on child, that is the Convention on the Rights of Child, that is CRC 1989. The different aspects of the CRC are covered by the different slides you can see. The convention recognizes the entitlement of a child to name and to acquire a nationality. Article 23 is important. The three optional protocols to CRC supplement the convention and expand the scope of relevant themes being addressed by the convention. It is also important to note that though these optional protocols work under CRC, but they are considered to be independent multilateral agreements under international law. So, the CRC and these three optional protocols under CRC, which are also of independent standard or independent identity or independent existence, these form very significant part of the international law to protect the rights of the children. This is all about the international law relating to women and children. Thank you.
Hello and welcome to this piece of literary snippet. We usually know William Shakespeare as the most revered figure in the history of English literature. But we often tend to forget that he has also been one of the most hated figures in literature. And here I am not talking only about those boys and girls who have to memorize long sections from Macbeth or King Lear or Julius Caesar before they can go and sit for their school or college exams, but I am also talking about people who are themselves quite famous authors. Tolstoy, for instance, considered the writings of Shakespeare to be, and I quote, crude, immoral, vulgar and senseless. George Bernard Shaw absolutely loathed Shakespeare, as he did Homer. But perhaps no other criticism about Shakespeare is more damaging than the one which says that Shakespeare is a marvelous storyteller, provided someone has told him the story earlier. Now, this piece of criticism is particularly damaging because it is true. None of Shakespeare's plays contain any original story whatsoever. They are all written using pre-existing materials, pre-existing stories. Now, does that diminish the stature of Shakespeare as a dramatist? Well, I'll leave that for you to decide. See you in the next episode of Literary Snippets.